panel on data protection regulators in the BRICS. We are promoting this panel from FGV Law School in Rio de Janeiro, together with the BRICS project run by Luca Belli, who is also a speaker in this panel. In this panel, we want to cover some issues regarding enforcement of data protection frameworks in the BRICS countries, and we also count with participation of Bruno Jack from the European Commission, who is leading from some years several actions regarding international data transfer. So the BRICS countries are hopefully interested for European Commission. I will start in the BRICS order, so I'll ask Luca Belli to be the first.
Thank you very much, Danilo. And also, I would also like to say that Danilo is the true data protection star here, as he is not only the father of the Brazilian data protection law, but also one of the few members of the newly created Data Protection and Privacy National Council in Brazil that I will mention at the end of my presentation. So as we do not have a lot of time, in the interest of time management, I will start by providing a couple of very quick remarks on what we are doing with this CyberBRICS project that we run at FGV. In partnership, so you can find all information on cyberbrics.info, including the material that I'm mentioning today. We are running the project in partnership with BRICS, very high-level institutions in the BRICS countries. It's really not only a pleasure, but an honor to work with them. You find all the necessary information on our website. So, what are the priorities of this project and why we are running a session here? First, I think there is some problem with, so first, analyze regulatory frameworks. So understanding what BRICS countries that are home to 3.2 billion people in the world are elaborating in terms of digital policies, which is already something extremely meaningful, as there is, in terms of academic research, a total desert of comparative analysis of digital policies in the BRICS, although they are extremely relevant, particularly in digital policies and the evolution of digital technology lately. Then after this first step of mapping, we can identify best practices and put forward policy proposals. We started by analyzing data protection and cybersecurity frameworks. Then we figure out that data protection in the BRICS context, but also not only the BRICS context, could be considered as one of the dimensions of cybersecurity, together with consumer protection, cybercrime, measures of implementation of public order, and cyber defense. So from micro to macro, from data to national defense, these are the 5 dimensions that we have explored into this book. You find the pre-launch brochure here. There are copies there. Feel free to have one, or you can free download it on cyberbrics.info. And as there are the reports on data protection in the BRICS in this booklet, but they are not very easy to read, you can also find on the website this interactive tool that allow you to check all the information we have mapped, comparing them amongst the BRICS countries. Again, cyberbrics.info, in the publications you find all the material I'm mentioning. Now, why data protection is particularly relevant for BRICS? The answer actually is quite simple and straightforward. There are 3.2 billion individuals living in the BRICS. Personal data are produced largely by individual and collected by any kind of device of application. And 1.6 billion individual is already online in the BRICS. So actually, if we consider data also for its economic dimension of the most strategic and valuable assets in the world, well, the BRICS countries are those who produce 42% of this asset in the world. Of course, they realized this some years ago. Not too many, but that is the reason why digital policies in the BRICS are very recent. But since the Xiamen Declaration in 2017, they agreed to jointly try to harmonize data protection and cybersecurity, and to put forward international norms on cybersecurity and data protection. Now, I cannot analyze all the BRICS examples, but fortunately there are some distinguished colleagues here that will do a great job with this. Let me focus on Brazil, particularly two things: the introduction of the new general data protection law, called also LGPD, that was approved in August 2018 and then amended with law 13853 of 2019, so 6 months ago more or less, with some interesting changes. If you want to read it and to understand how BRICS, the B of BRICS, Brazil, is regulating personal data, we have just finished the unofficial version, English version of the LGPD. Is the only one that has all the provisions updated with the law 13853. So it's quite interesting to give a look to the law. And actually, you can see that there are a lot of elements that are largely inspired by the GDPR. Of course, due to the more or less similar time frame in which this was debated, you can find, for instance, the principles listed at Article 6 of the Brazilian law. They are very much compatible with GDPR, with a little bit of different denomination. For instance, data minimization in Brazil is the principle of necessity. You can also check what are the legal grounds for data protection that are a little bit more elaborated and expanded compared with GDPR, but if you compare them, they are almost exactly the same, with the exception of protection to credit, which is the Brazilian specialty. Also because at the same time, the new law for the positive credit history was also approved. So in Europe, that would be considered legitimate interest. In Brazil, is considered a special ground for data processing. Rights of the data subject, I'm not going to list them all, but if you check Article 18 and then a little bit of Article 9 and 20, you find all the articles that more or less you will, all the rights that more or less you will find as data subject in Europe. Now, what is very interesting for us today, the National Data Protection Authority. It was initially vetoed by the president, then reintroduced with a provisional measure at the end of December of 2018, which was probably the last day of work of former President Michel Temer. And then with law 13853, this year was reintroduced with a little bit of different flavor. It is not, according to Article 55, an independent body. It is directly attached to the cabinet of the President of the Republic, but in 2 years can be reviewed and transformed into an independent authority. So far has been created as a dependent agency from the presidency, but can be transformed in an independent body. Now, all this is on paper, because the decree that actually defines who is going to be running the agency and what are the details to be part of the agency is not approved yet. Rumors say that it should be approved over the next weeks in February, but those are only rumors so far. The structure of the regulator includes a board of directors that will be chosen by the president and confirmed by the Senate, a National Council for the Protection of Personal Data and Privacy that has 23 members. So far, only 3 are known. One of them is this gentleman here in the middle. And then an administrative structure with internal audit, ombudsman, legal advice, and some units, but no one knows how many people will work there and how those individuals will be chosen. So far, it's a little bit of a black box. There are a lot of urgent tasks that the regulator will be called to perform and to take decision on. And let me remind you that the LGPD, the legislation, will enter into force on the 1st of August. And the regulator that has to provide guidelines and regulation on this, these are only the urgent matters, has not even yet been created. So it will be a sort of pharaonic task when it will be created to implement all these, and a little bit of suspicion, of course, is more than accepted, because it is very difficult to. Those are only the urgent tasks again, and there are some very relevant tasks, like defining which procedures data subjects have to use in order to have access to their data, or which are the criteria for data portability, how data breach should be notified, in which terms, how the data protection officers, which kind of function will have to have, and when are they necessary or not. Those are quite important tasks. I'm done with this. Of course, you can find all the information here, and also on the interactive tool, also on on cyberbrics.info. And of course, this is a conversation that it is to be continued, because it's far from being finished. So thank you very much for your attention.
Thank you, Luca. I'll pass the floor to Andrey Shcherbovich from Russia.
Thank you very much. Can you hear me well?
Very well.
Thank you very much, dear colleagues. Give me this slide.
Sorry.
Could you start the presentation, please?
PowerPoint, please.
I will talk about the data protection and data localization regulation in the Russian Federation, which is slightly recent legal developments. But let me say first general observation, which I checked from the conference in general. We're talking about data protection, but all we need to talk about not data protection, but users protection. Russian law is designed generally for data protection, and it could impose some restrictive measures against users' rights. But let's check for the beginning. I will talk about the general attitude to the personal data in Russia, that personal data is not extreme important phenomenon for Russian citizens morally, because since 90s, all personal data could be found, of all citizens could be found in illegally sold CD disks, CD drives on the black market. And now it could not so easily found, but it could be found on the dark side of the internet, actually. And we simply don't have term privacy in legislation. We have term privacy, which could be translated as inviolability of private life of citizens. I think the term privacy could be actually reproduced in Russian legislation without any translation. It could be really more simple. So we have a general law on personal data, which was originally adopted in 2006, and it's aimed to protect privacy of individuals, and has some economic, social, and other functions, and political, of course, functions, and we will discuss this political attitude a bit further. And what is the competent authority of the Russian Federation that implementing this law? This is well-known Roskomnadzor, which is federal body of supervision in sphere of information technologies and mass communications, which also implementing some such restrictive, in my opinion, legislation provisions as the sovereign internet law and some other restrictive measures. We can outline here some functions of the Roskomnadzor, which is supervision, compliance control, and personal data processing, which is consideration of appeals of the legal persons and individuals in sphere of data protection, which is keeping a register of operators engaged in personal data processing, which implements measures for improving protection of the rights and collaboration with foreign authorities. What are the problems with the international law in this case? We can see that the Council of Europe Conventions, Russia is not part of GDPR, of course, and so it's part of the Council of Europe Convention. And the Council of Europe Convention divides countries in three categories. The member states, countries providing appropriate protection, and other countries. What is the problem with Russia in this case? Why it's in sphere of other, in category of other countries? Because Russia, Russian body, the Roskomnadzor, is not independent. It's structurally dependent on the Ministry of Mass Communication of Russian Federation. And that's a problem because according to the requirements of the convention, the bodies should be independent. And we can see the major problem in personal data legislation in Russia, which is localization of personal data. It's a very famous requirement, which considers that duties of the personal data operators for accumulation, storage, clarification, and retrieving personal data in the database located on service only inside the territory of Russian Federation. So that imposes very strict problems for the cross-border data protection for Russian citizens. And we can see the Roskomnadzor's register of violators. It's in Russian, but we can see it here. This registry. You cannot check all items of the registry. You can just check if the website in the list, but you cannot see the whole list on the website of the website's violators. We can see some problems of the data localization law. First of all, experts believe that this entry in the force of this law decreasing countries' GDP. The law creates problems for cross-border data protection, and also it's not possible to establish the accuracy, the nationality of internet user. For example, if I have in my auditorium foreign students which are not Russian citizens, but they are using Russian mail servers, for example, in email from provided by the university. Should their data be located in the territory of the Russian Federation or not? And how to deal with this? And also, it's quite easy to bypass these requirements technically by using VPN stores, and you cannot simply find yourself as a citizen of the Russian Federation or not, or the citizen. Also, there is the strengthening governmental control of the overall internet activities by this. For example, this is like a provision of this sovereign internet law. We are not talking about this law in this panel, but the major issue here now in Russia that Russia created the sovereign internet law, and it prevents mass-scale loss of personal data. If internet becomes isolated, it's additional opportunities for Russian law enforcement agencies and additional control, instrument of control over distribution of unwanted content. Here is the case study with the social network LinkedIn. which is completely banned in Russia due to non-compliance with the personal data law. We can see some possible outcomes for the Facebook and Twitter. Roskomnadzor imposes some fines due to the court decision for the Facebook and Twitter due to the non-compliance. And the next possible step is possible blocking of Facebook and Twitter in the Russian Federation, which is also because the auditorium of the Facebook and Twitter is larger than in case of the LinkedIn. And so I suppose that finally localization of personal data is not protection of citizens. It is a restrictive measure that could be refused from the legislation to ensure more freedom for Russian users. Thank you very much.
Thank you, Andrey. Our next speaker is Anja Kovacs. She's director of the Internet Democracy Project in New Delhi, India.
Thank you, Danilo, and good afternoon, everyone. As Danilo said, I work with the Internet Democracy Project in Delhi. We work on realizing feminist visions of the digital in society through research on norms, governance, and infrastructure. We're part of the CyberBRICS network, and in 2019, I was the India Fellow, and we're also part of an India network called Data Governance Network, which is specifically trying to develop more knowledge about data governance issues, specifically in India. I am not going to go through our current proposed data protection bill, which is was tabled in Parliament in December in detail. But I want to focus on two particular areas, which is the Data Protection Authority and the sections relating to state access to data. The reason for that is that a committee was instituted in 2018, even though India is supposedly a global IT superpower, and the debate around data protection has started as early as 2006. We still didn't have a bill, and this government finally decided to move on that, installed a committee actually in 2017. They came up with a draft bill in 2018. The most positive responses, I think, to that version were that it's a GDPR light. The most negative ones were that it didn't actually guarantee users' rights, but that was more a framework to ensure for businesses to know when they would be liable or not. The 2019 version, though, was judged by the justice who headed the committee that led to the 2018 draft, as setting India on the road to an Orwellian state. And that's why I've chosen these two particular areas, though there is much more criticism that one can give of this bill. Specifically on the Data Protection Authority, which is very much part of the problem. To start with, I'm going to focus on the question of independence, because that's really the challenge here. So the selection committee for the authority will consist of people from the executive, 3 secretaries, people from the executive only. This is a problem because what we have seen in the past is that, to start with, in those cases, very often former bureaucrats are actually appointed to be head of the regulatory authority. Now, in the case of the Data Protection Authority, the tasks that has been given in the bill are actually quite wide. To start with, it has to put into place many foundational regulations and practices. The list is in the bill, it's very long. For specifically where codes of practice are concerned, the bill says that these would require a transparent and consultative process, although there is no detail on what that means. But for all other regulations, the bill is actually silent on the process. And so that will really be left then to either the government or the authority to decide. This is problematic, again, because, for example, there is a provision that allows for social media intermediaries in particular to be labeled significant data fiduciaries, which will have a higher burden of responsibility. And in the case of social media, significant fiduciaries in particular would also be asked to start providing mechanisms for social media identity verification. A second issue is, or an example of the reason why the strong influence of the government on the composition of the DPA is problematic, has to do with the fact that there is a provision of a sandbox for startups in particular. If the sandbox, or if a business is approved to be part of that sandbox, they supposedly have to work towards innovation in artificial intelligence, machine learning, or any other emerging tech in the public interest. But these conditions have never been defined, so neither innovation nor public interest is defined in the bill. And so the question of who will be included, who will be excluded is quite important here. If you're in that sandbox, you, for example, don't have to adhere to the provisions around purpose limitation, collection limitation, etc. So really the impact of this is quite important. And then thirdly, the challenge of the strong government influence also has to do with the fact that the Data Protection Authority will be responsible for overseeing the state as well. And that has, again, important consequences. So to give you one example, if there is a data breach, according to the Act at the moment, the fiduciary has to, we use fiduciary, sorry, I didn't explain that, I think. In the Indian bill, we use data fiduciary rather than data processor. So the fiduciary has to alert the Data Protection Authority that a breach has happened, but it is the Data Protection Authority who will decide whether or not the data subject actually has to be informed of this breach. And so again, that very close interaction between the state and the authority there are just cause for concern. In addition, and this is really quite remarkable, there is in any case a separate provision in the Act that allows for a curtailment of the powers of the authority, where the central government can issue directions on policy to the authority, and I'm quoting, as it may think necessary in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, or public order. And the authority is bound by such direction. The central government's decision on what is policy is final. The internet shutdown in Kashmir, which is now the longest in a democratic country, is also one of the issues that come under public order. So the independence of the authority is in question, but like I said earlier, many people have raised questions also about, among other things, the powers that the state itself is giving itself over data. How am I doing on time?
You have 4 minutes.
Great. First of all, there are a number of, let's say, civil causes. So one of the grounds for processing, apart from consent, is for the performance of any function of the state authorized by law, including the provision of any benefit or service, or the issuance of any certificate, license, or permit. Other grounds that the government can also draw on are those related to employment, which for reasons not very clear have been included specifically in the bill, and include any activity related to the assessment of the employee's performance. The state can also draw on a provision that says that processing can happen for reasonable purposes, which include the prevention and detection of any unlawful activity, including fraud, credit scoring, recovery of debt, and processing of publicly available personal data. That last bit is interesting because we already have, we know that several police departments across the country are using social media data to conduct sentiment analysis and the like. But apart from that, there are also specific exemptions from the state. The central government can exempt any agency from the application of any or all provisions of the bill, again, in the name of security, friendly relations with foreign states, sovereignty and integrity of India, public order, or for preventing incitement to the commission of an offense related to any of this. And I think that the emphasis on prevention of offenses in particular is quite dangerous because that really opens the box to almost everything. Large sections of the Act do also not apply in a number of instances where personal data is processed in the interest of prevention, detection, investigation, etc., of offenses in any case. and that includes the entire chapter of data principal rights, doesn't apply, or the obligation of data fiduciaries, except that the processing has to be clear, specific, and lawful. All of this is really quite worrying also because, one, the bill treats the state as unitary, so it's not clear at all whether there is no real obvious ground for intelligence agencies not to access, for example, data that has been collected for the provision of a service. There's no siloing of this access. It's also concerning because in India, in any case, most intelligence agencies have been established by an executive order, not a statute, and there is no parliamentary oversight. There is at best executive oversight. The safeguards that were there in the earlier draft, which at the Internet Democracy Project we thought were quite weak in any case, but they did include, for example, a reference to necessary and proportionate surveillance to be necessary, and those have all been removed, which is why Justice Sri Krishna ended up calling the bill Orwellian. Right. I think I should probably finish here. Can I already ask a question also, Danilo? Because I'm really pleased. I was so pleased Bruno was here. Because we were really wondering. It was somewhat surprising to see the bill go in this direction, because we know that the government is concerned about advocacy for the GDPR as well. And so I would really love to know your thoughts on that, whether with the current version that's feasible at all or not. Thank you.
Thank you very much, Anja. I believe Bruno can answer.
This easy question.
Yes, this is a question, extension of his time afterwards.
It's of course a yes or no answer.
Maybe short or not. So we pass, the next speaker is Sizwe Snail. He's Commissioner at the Information Regulator of South Africa. Please.
Thank you very much. Good afternoon, everybody. I wear a lot of hats. I'm a practicing attorney, actually, specializing in cyber law. I also teach cyber law at the University of Fort Hare, but for the purposes of this exercise, I'll represent the information regulator, of which I'm also a commissioner. I'll be talking to you about the data protection legislation that we have in South Africa. We call it the POPIA, or the Protection of Personal Information Act, Act 3 of 2013. I'm very specific about that because we are now in 2020. So this is 7 years ago. But our authority is only 3 years old, and we have only started actually doing effective work within the data regulation space in the last 24 months. But just to contextualize data protection in South Africa, unlike other countries who will acknowledge data protection to saying, yeah, it has its origin from Europe and so forth, we use a different approach. We say we have a constitution, and our constitution protects the right to privacy. And as one of the sub-facets of privacy comes data protection. So the antecedents of our data protection law, as much in terms of international best practice, we do obviously follow European best practice to some extent, all has its foundation in the right to privacy. Now, the Protection of Personal Information Act is an amphibious act in the sense that it doesn't only deal with the right of data protection, but it also deals with the opposite right, which is access to information. Our regulator is, I think, the only regulator in the world that actually deals with both data protection as well as access to information. And once again, I think it has itself the foundation based in our Constitution, because the right to access to information is also included in our Constitution in Section 32. Therefore, you have these two opposing rights that had to be brought into one piece of legislation. Now, the information regulator is independent. We report directly to Parliament. We are not under any department be it the Department of Justice or the Department of Communications. Yes, they have helped us set up. The Department of Justice had to help us set up. Someone had to help us set up. But we've now moved our offices from the Department of Justice. We are actually opposite the Constitutional Court. We are now the neighbors of the Human Rights Commission, which brings me to the second focal point, to say the information regulator doesn't only say that we're dealing with data protection from a technical perspective, but we look at data protection as a human right. And in terms of that, this unique mandate that we have of having to balance access to information and data protection will come out quite clear in this presentation later on. So we consist of 5 members, all of which are lawyers, by coincidence. It's our chairperson, Advocate Lakula, and we have 2 other advocates as well, a law professor as well as myself, who's a practicing attorney. And what we are basically doing is we are the body that regulates data protection and access to information separately now from the South African Human Rights. The South African Human Rights Commission previously was the institution that gave effect to the human rights, but as early as 2010, it was felt that a separate independent institution should be formed, and in December 2016, the Information Regulator was born. To what does POPIA apply? Some call it POPI, some call it POPIA. We prefer to call it POPIA because in one of the languages that we have in Afrikaans, a poppy refers to a particular young lady. So one of the professors that was one of the members, she said, no, we can't call it a poppy. Let us call it POPIA. So we call it POPIA. It applies to basically any processing of personal information to the exclusion of household activities and other activities that are authorized by law. Just from a language perspective, you will know that South Africans like to be very different. We do call the data subject a data subject, but it's definitely not a controller. It's a responsible party, all right? That is what we call it. Obviously, we use it synonymously with data controller, but responsible party is what we call it. And then he or she or it who processes personal information on behalf of a responsible party is called a operator. Now, the act is a pre-GDPR act, my emphasis, in the sense that when you look at our conditions for lawful processing, or better put, the principles pertaining to lawful processing of personal information, you will see that we have accountability right there on the top. We have process limitation, and process limitation underneath that obviously is the requirement of lawfulness, which is a constitutional requirement. You will see your minimality, it's there. Consent as well as there, willful consent, as well as the collection of information directly from the data subject. We have the purpose specification requirement, which I think is straightforward, the prohibition on further processing, as well as the principle pertaining to information quality to say that there is a positive duty on a responsible party to maintain the quality of the information. Openness, once again, is there. I think that's relatively straightforward, including documentation and notification. Then my pet project, security safeguards, all right? The whole issue of technical and organizational safety guards, the what to do and what not to do in the event of a cybersecurity breach, notification to data subjects about the breaches, as well as reporting yourself or self-reporting yourself to the Data Protection Authority in the event of a data breach. Then we have the last principle, which is data subject participation, which I think is also relatively straightforward. We then also have a couple of other categories which we call special personal information. That would be information regarding your political views, your union membership, as well as your certain health informations that you may have. Those are expressly prohibited from processing unless there is either an exemption or there has been a consent from the data subject or there is any other piece of legislation that authorizes that. You will recall there was the requirement of lawfulness, which then obviously interlinks with that to say that if there's any piece of legislation that lawfully allows the processing of that information, then that obviously must also be permitted. There are consequences for non-compliance. We have our own, should I say, dispute resolution mechanism in terms of if any of the conditions is breached, you can bring a complaint to the information regulator pertaining to that, as well as the self-reporting mechanism and reporting mechanism to data subjects as contained in Section 22. Well, what do we do when we get a complaint? Well, we receive it, we register it, and then by way of the audi alteram partem rule, a investigation will ensue. There are certain powers that the regulator has, which have unfortunately to date not been put into force. Currently, it is sections 1 and up until sections 39 that are in force, as well as sections 45 to sections 59 and sections 112 and 113. Those are primarily the sections that dealt with the establishing of the regulator. We started this organization completely from scratch. Like I said, the offices were completely empty. There were no computers. There was nothing. There was just people. But I'm proud to say now that it's not just people now. We do have machines. We do have executives. And the Office of the Regulator is growing steadily. Before I left yesterday, we were actually editing a letter to the state president asking the state president to put the remaining sections into force. If there's any South Africans here, now you know when POPIA is coming into force, because that is the question we've been getting for the last 2 years. When is POPIA fully coming into force? It is definitely coming into force in the second quarter of 2020. We also have an enforcement committee. In other words, there was this whole notion to say, do I still have time? Yes? Oh. There was this whole notion to say that the South African Human Rights Commission did not have teeth. In other words, you could go to the Human Rights Commission, complain about a particular right that's being infringed, but to get relief, you would still have to go to court. In terms of the enforcement committee now, we are in the process of actually writing to the Chief Justice. He needs to assist us to find a judge or a legal practitioner that will head the enforcement committee, that will have the powers, almost quasi-judicial, to a court in terms of enforcing the decisions of the regulator, as well as other investigative powers. Obviously, in the case of non-compliance, there will be certain fines that will be imposed, administrative fines, as well as criminal sanctions. That's the slide that dealt with what I told you just now. So I'm going to skip that one. Let's see, are we moving? Okay, good. Then just to let you know, what have we been doing over the last 3 years? We haven't just been establishing, but we've also been party to some interesting litigations. The case of Black Sash versus Minister of Social Development was a very interesting case where the Ministry of Social Development that was giving social grants had appointed a third party to give out the grant benefits. Unfortunately, within that organization, and I need to be very careful how I put this, within that organization, there were certain abuses and misuses of personal information. The Constitutional Court then had to deal with this, And indeed, it said that the personal information that was obtained of grant beneficiaries must be used specifically for the purpose of paying grant beneficiaries only, not to send them advertisements for airtime and insurance policies and other products that were being given there. There was also a section that dealt with direct marketing, to say that in terms of direct marketing, we now follow a opt-in regime and not a opt-out regime as previously. There's also the issues regarding the Electoral Commission. There's also the issue regarding the Electoral Commission and the use of personal information in elections. We are actually busy with a colloquium next week that I'm organizing with the chairperson, where we're going to discuss these matters. And last but not least, the two current matters that are before court. Ironically, it is the current president of South Africa who is fighting with the public protector about his personal information and the personal information of his party. And in another litigation, it is the former president fighting with the South African Revenue Services about his tax information. What is our position? We've taken the position of amicus curiae on both matters, and we will leave that to the courts. My time is over. If you want to hear more about our organization, we can chat after this. Thank you very much.
Thank you. Now our next and last speaker is Bruno Gencarelli. Bruno Gencarelli is head of international data flows at the European Commission. Now Bruno can make his presentation and maybe answer any question.
How much time?
10 minutes.
Okay. International data flows and protection. That's very important because we do both. And
The flows and protection, Clash.
thank you very much. But first, thank you for having me as the non-BRICS exotic member of your panel. What we've just heard is extremely interesting, and it's confirming something we believe very much in the European Commission, the European Union, is that in a world which is often characterized by a different, divergent, fragmented approach, privacy is one of these few areas where convergence is really increasing. And that's real, and it's happening before our eyes, as we've just heard. When I started to work on these issues, negotiating the GDPR and the Law Enforcement Directive, so not so much time ago, but still some years, I was hearing three statements, which I thought were three myths about data protection and data protection rules. First, this is a European obsession because it's very much linked to your history, some cultural aspects. I'm always very concerned when, especially in the field of human rights, I hear cultural relativism, arguments about cultural relativism, but that's something you could hear even a few years ago. And they don't care about privacy in Asia, for instance, because of the way the society functions, or this is a luxury human right, etc. And for instance, the Indian Supreme Court has told us exactly the opposite 3 years ago, that this is actually an essential facet of human dignity, full stop. Second thing we were hearing is this is outdated. Who cares about privacy in the digital society, the digital era? Third thing, too complicated. Too complicated for legislators, too complicated for enforcers. Leave this to the business. This is about best practice because this is complex from a technological point of view, because this is about a fast evolving environment and you will never keep the pace. I think that all this has proven wrong. And what is interesting about privacy, and what is, I think, was reflected in everything we've heard, is that because privacy is, I would say, at the intersection of human rights, but it's also more and more also about the functioning of our democracy, including the integrity of our electoral processes, and it's an economic necessity for having a sustainable development of increasingly data-driven economic world. We are all trying to seize the similar opportunities and facing very similar challenges. And we are equipping ourselves with legislation that don't need to be identical and they will never be identical, but that are increasingly based on a common set of principles. Having an overarching legislation rather than sectoral rules, having a core set of enforceable rights, and having a regulator, a independent regulator. Independence is essential if we want to have a legitimate and a trusted player who can investigate and adopt decision in individual cases. We can also develop guidance, which are so needed because of those fast evolutions I was referring to, and that can happen only if that body is independent, is independent, and thus can be trusted by all the stakeholders. So yes, we have, of course, I've heard some of the question marks about independence, but also from our European experience that this is a difficult and a dynamic process. In the EU, we had to bring 3 member states to court because of the lack of independence of the Data Protection Authority, and we won each time. But it shows that this is not always an easy process. I also note that in Brazil, this is a sort of 2-step process. There is in the legislation a sort of rendezvous clause in 2 years to strengthen the autonomy, at least the functional autonomy of the authority. So that convergence is of course very welcome. We believe that it's actually a win-win situation for us and for our international partners. It increases the protection of the data of our citizens and of the citizens of those third countries when that data moves. It also significantly facilitates trade and cooperation between public authorities, including cooperation in the law enforcement sector. The concept that we are hearing about free flow of data with trust, of safe data flows, that's also a change of sorts of paradigm compared to what we were hearing a few years ago, that actually high standards of privacy are an enabler, are a facilitator for trade, for cooperation between public authorities. And those are not different or opposite objectives. So what do we do to facilitate or build on that convergence? We are, of course, exploring and developing tools such as, for instance, adequacy decisions with a number of our international partners. We have, for instance, this year we have concluded a mutual, last year, it's already last year, we concluded a mutual adequacy decision with Japan. We are finalizing an adequacy process with South Korea. We are working on potential adequacy depending on the outcome of certain legislative process with a number of Latin American countries. Africa is an extraordinary laboratory in terms of new initiatives and new developments in the area of privacy. We are also increasing, and that's also very interesting development, we believe, we are also increasingly working with regional partners. There are a number of organizations, regional organization networks, such as ASEAN, such as the Ibero-American Data Protection Networks, such as the African Union, which are increasingly playing an important role in shaping data protection standards, in facilitating cooperation between data protection authorities. Those are new but very important actors at the time where there's a real demand for international standards in this area. Does this mean that everything is fine and works perfectly? Of course not. It's a difficult process. I mean, we took a number of years to adopt modern legislation on data protection. We also are still in a phase where we are I wouldn't say struggling with the implementation and enforcement, but testing the new powers that have been given to our data protection authorities, the way we also work together within the Union, because we have a new decision-making process, a new governance system by which all our data protection authorities have to work together when they look at cross-border case. Another challenge we see more at the international level is sometimes that, to use of a simplistic, of course, formulation, that data protection and data protectionism can be sometimes confused. There are measures, I'm thinking, for instance, of certain forced localization measures that have nothing to do with a genuine data protection legislation, but where data protection can be used as a pretext to introduce such protectionist measures. We try to develop a system which at the same time ensures a high level of protection but is open to data flows. And that's also why we are very interested in working even more intensively with countries such as the one which are represented in this panel and many more of your like-minded countries which are already working with you. Thank you very much.
Thank you very much, Bruno. Just before I pass the word to the floor, just wanted to make a very small addition to the presentation Luca made about Brazil. And as Bruno Gencarelli also mentioned, the question of independence of the regulator, of the DPA. The Brazilian DPA, as you saw, is not yet formed, but it is legally inside body of the direct public administration, which is the Presidency of Republic, which makes it non-independent at heart from start. There's this trigger which can make the DPA independent within 2 years if a revision is made, and if in the revision process, it will be decided to turn the DPA into an independent body. But there's also another thing. There's an amendment, a proposal of amendment to the Constitution, which was proposed last year, which, if approved, would make that protection a fundamental right inscribed in the Brazilian Constitution, would make that protection federal competence, which is Brazil is a federation. So if the amendment passes, only the federal legislator can make laws on data protection. But the third thing is that the fundamental right to data protection shall be supervised by an independent authority in terms, similar terms to the European Charter of Human Rights, Article 8.3. So this legislation has not been approved yet, but if it passes, it will make the revision process useless because the Constitution will basically command the government to create an independent body. And now, just before I pass the word to the floor, I believe Sophie Kwasny has a comment to make. Sophie, please.
Thank you. Good afternoon, everyone. Thank you. And thank you to the Getúlio Vargas Foundation for organizing the panel. It was very interesting. Just a clarification about the presentation of Andrey on the Russian Federation accession to Convention 108, to highlight that the Russian Federation acceded to the original text of 1981, Convention 108, and that accession, the ratification was in 2013, but that the Russian Federation never ratified the additional protocol of 2001, which deals with independent supervisory authorities and transborder data flows to non-parties to the convention, precisely because I think that the Russian Federation took very seriously the commitment of ratifying this international treaty, knowing that Roskomnadzor would not qualify for the commitments under the additional protocol. This is also demonstrated by the fact that the Russian Federation has been very active in the modernization of the convention, and that the Russian Federation was one of the first countries to sign the modernized convention, but still has not ratified because they are perfectly aware of the fact that there needs to be a revision of the national system, and independence granted to the supervisory authority, because under one weight modernized, one weight plus, this is a key condition, and so they would not comply with that obligation. So that's something I wanted to clarify. They have not ratified the additional protocol, so they are not bound by our text on the independence of the DPA for the time being, and only to invite the two letters that are missing in the work of the committee, that is South Africa and India, to contribute to the work of the committee as observers, as Brazil is doing, for instance. So please, this is a call, come to our meetings in Strasbourg. Thank you.
Thank you, Sophie. Now, does anybody has questions, please?
Just a clarification, because some of you may be wondering where is the sea of China. Today, Chinese people are celebrating the lunar year, New Year's Eve. So it's like if we organize the panel on the 31st of December for non-Chinese people. So it's with these dates, it's virtually impossible to have Chinese participating. So apologies. But we have substituted the Sea of China with the Sea of Commission.
We would love to have the same weight. So
It's a very smart move.
Happy Chinese New Year, actually.
Yes, exactly. To all the non-Chinese here.
Okay. So I have two questions, please. Please identify yourself.
Yes, my name is Marla Luther. I work for an NGO in Germany. And my question is, I really appreciated Mr. Gencarelli's comment about how, at the end of the day, the data protection legislation that we enjoy or we have in Europe is not a uniquely European phenomenon or policy, and that it's a huge facilitator for international business relations at the end of the day. So I wanted to ask, I mean, then things look quite good, I think, for a future economic relationship with South Africa, but I know that there's interest in creating a free trade deal with India as well. I think, unfortunately, Russia is out of the question. With Brazil, there's also discussions going. So how are we going to make sure that we reward those partners that also have a similar set of legislation to our own? And how do we account for the fact that the missing person at this panel is, at the end of the day, we're doing great trade with them? Yeah.
Thank you. Would like to.
Okay, I'll talk about South Africa. I think, historically speaking, South Africa and Europe have had very, very good trade relations. Even during the apartheid time, even when things were banned, Europe still had good trade relations with South Africa. And my emphasis about apartheid maybe goes to the undertones to say that apartheid in itself was also an infringer of data protection. So I agree with my learned colleague over here to say, you know, why do we always bash Europe and say it's European antecedents? It's not European antecedents, it's an international phenomenon. So I don't think in terms of further trade with South Africa, there will be anything impeding either revision of our current law or considering acceding to certain conventions. You will notice, for instance, South Africa is a signatory to the Council of Europe Cybercrime Convention. South Africa as a country is not necessarily resisting European things. But with that having been said, we do have a constitution. And our constitution is very clear about international law. Section 233 says South Africa must consider international law. So in terms of that, even when we interpret our own laws, we always consider what is happening internationally so that we don't get left behind. I hope that answers that aspect.
I'm not sure I'm going to answer your question because I think there were different elements, and depending on what you emphasize, the answer will be very different. But first of all, so in my reading of the current version of the bill that we have on the table, it is actually quite different from the European perspective. And I think historically this has actually been the big tussle in India, The two big forces that are driving this legislation is, one, the desire to have a strong digital economy and the recognition that data protection will be part of building an ecosystem that provides security, including for people as consumers. Though we have a Consumer Protection Act as well that was updated specifically to deal with e-commerce. And I think that was much less controversial precisely because it focused on consumers and not citizens as such. So it's a more narrow bit of that whole scheme. But on the other hand, we also see that both cybersecurity and data protection in India have strongly been driven by concerns about state security. And this is true since the early 90s when there was an uprising in Kashmir which against Indian rule at that time. And it's true, I mean, we can't deny this either, right? In Delhi, like in my neighborhood, we've had terrorist attacks. These things happen, they're real, they're very close by, and they were close by long before they came to Europe. So these two thugs, I think, have been very real. And on top of that, and I think this is one of the criticisms that we have in our work at the Internet Democracy Project of the way we look at these issues around data governance in general, is that we don't recognize enough that data protection is only a very little part. And I think part of that really comes, and this is the focus of our work at the moment, that we talk about data as a resource. And if you talk about data as a resource, as this thing that's out there, then you can start to look at it as something that can be mined, that you can move around, and that isn't integral to human rights protection in the same way as some other things are. And I think India, with its very specific context, both in terms of security and in terms of the potential of data to lift the economy to another level, is just taking that to its logical extreme. So I have lots of issues with this bill. I think it has real dangers for human rights in the country. But I also think if we want to question that, we need to start by really questioning this narrative of data as a resource. And what we do, so this is not about metaphors. In our work, we start from marginalized identities. We start from people's experiences with what happens with data. And so we talk about data as embodied because the harms that people experience are actually often very physical, right? And in extreme cases in India, that is, for example, around, you might have heard these stories about Aadhaar, our unique ID. If you use that to go to a ration shop, the shopkeeper might have known your family for 30 years, but often, if your fingerprint identification fails, you won't, in many cases, get these rations. You should under the law, but in practice, it often doesn't happen. Now, people have died of starvation. That's as a consequence. Is that a data protection violation? That's a violation of the right to life, right? We have endless lists of examples like that. So I think if we want to push countries like India really to a much more strongly human rights protection stance on these issues, this is really critical to question. And every single policy that we have, the government uses that language of data as a resource and even extends it to talk about data as a national asset, something that you give in trust to the government, that the government will work with for the benefit of the nation, right? And that's possible if you don't see this link with bodies. So I think the issue, if we really want to come to that closer agreement, has to start there.
Okay, Bruno?
Yes, very quickly, and indeed there was a question with many entry points, but essentially this was about the relationship between data protection instrument and trade. Those are two separate tracks, also for the EU. They can complement each other. And of course, if you have a trade deal and if you have the convergence we were discussing here, it can be an additional facilitator, it can complement, enhance even the benefits of a trade deal. That's what we have done with Japan. We had a free trade agreement with Japan, and because the Japanese and the European legislation were sufficiently close or comparable, or were delivering a sufficiently comparable level of protection, we could also have an adequacy decision. By the way, an adequacy decision is a quite unique instrument we have, which almost assimilates a third country to a member country of the EU, and therefore extends the benefits of free flow of data to a third country, which is clearly not subject to rules. So that's why also the criteria are quite demanding. But an adequacy decision is not negotiated within or in a trade agreement. We don't negotiate, none of the countries here negotiate fundamental rights in a trade agreement. It is subject to its own condition. I totally agree with the apartheid example. It cannot be taken in isolation. It's about the whole architecture of a country in terms of access to justice, judicial redress, non-discrimination, exercise and enforcement of human rights. A very important also message with adequacy, it's not about identity. We perfectly understand that systems, because of legal tradition, because of the societal choice, make different choices. Adequacy, it's about having a sufficiently of looking at two systems in their globality, in their entirety, and assessing whether the two systems deliver a comparable level of protection, using often different means. There are, of course, essential requirements, which are the ones we have discussed. You need to have enforceable rights, an independent authority, recognition that this is a fundamental right, a human right. What we are simply saying, and this is not about rewarding, this is not about a beauty contest, it's not about rewarding certain countries rather than that, but what we are seeing is that we are increasingly converging, and that convergence offers new opportunities in this field, which are, we believe, very beneficial both to individual citizens and to businesses.
Thank you. We have time for a very quick final question, but before that, Luca.
Yes, two very quick comments. One, a comment on what Bruno was saying about not having adequacy out of Europe. Actually, BRICS countries are proof that is not entirely like that. Out of the 5 BRICS, only Russia does not have an adequacy process. Article 34 of the new Brazilian law has a sort of adequacy process, and also the Indian bill, even the Chinese and the South African framework have it. And actually, even if we do not have any Chinese here, I wanted also to provide a comment on China, which I think should be studied more to understand truly how data protection is framed there. We always start from a lot of preconceptions that are sometimes absolutely true, sometimes need to be challenged. China has introduced a right to protection of personal information in 2017 in the new general rules for civil law. It has introduced protection of privacy in the cybersecurity law. It has recently adopted the cybersecurity, information security specification. And although, of course, data protection is framed more in business terms, Chinese people are perfectly aware that data protection is extremely important for business. So it is, I would challenge the critiques that arguing that in China data protection is not an issue. It is an issue. There are even consumer associations currently challenging many practices of businesses. If someone wants to take a copy of this issue of China Today, published for the BRICS symposium in Brazil, there is an article I authored about the need for strong data protection in the BRICS, and this is published by the official press organ of the Communist Party. So it means that Chinese are not reluctant to hear and to understand data protection. Of course, there are different flavors of the same issues, and I think it's also part of the non-Chinese effort to understand this kind of culture, to at least sit and try to understand them and study how they are regulating things, just to clarify.
Yes, thank you very much. I'd like to really short clarification. Anyway, Russia is a European country, and a member of the European integration, is a Council of Europe member, and I believe that European frameworks, especially, should be implemented as our colleague from the hall. Thank you for your clarification, but I believe, as an international lawyer, I believe that signature of the head of the state under the documents means not the obligatory as the hard law, but means the soft law force of these protocols. I believe that for the same happens in other spheres. For example, abolition of the death penalty, for example. These protocols are not ratified, but death penalty is not executed in Russia as the member of the Council of Europe. I believe it's the soft law rule means that. And I think, but we have some constitutional changes. That means another role of international instruments. So we can see what will happen after. But at the moment, I believe that international rules should prevail, even for data protection. Thank you very much.
Thank you. Unfortunately, we won't have time for the final question. We would ask the one who would make the question to find directly the ones who want to answer the question. And I thank you very much for all the panelists. It was very interesting.